Welcome to the Deep Dive. Today, we're taking a deep plunge into a subject that might seem a bit dense on the surface, but trust me, it shapes so much of our daily lives. We're talking about administrative law, and it's absolutely crucial for anyone looking to navigate the legal landscape or even just understand how modern society actually functions.
It really is fundamental.
And we'll be focusing today on a key introductory document, guiding you on how to approach its study for maximum understanding and, crucially, for exam success.
That's the plan.
Before we begin, we want to extend a massive thank you to the University of London for making these invaluable educational documents available to students worldwide.
Hear, hear. A fantastic resource.
Please note, this deep dive, like the materials it's based on, is for educational purposes only. Our goal is to empower your learning journey.
Definitely. Education is key.
And this deep dive is proudly brought to you by Sinorbit Academy, Sri Lanka. We wish all of you the very best of luck for your upcoming exams.
Absolutely. Good luck, everyone.
You've got this.
Indeed. Our mission today is really to distill the most important nuggets of knowledge from this foundational text.
Okay.
Think of it as a comprehensive guide to kickstart your administrative law journey and set you up for success. We're going to give you a clear roadmap highlighting critical concepts.
Which is so important for exams.
Exactly. And even sharing insights on how to approach your studies and the assessment itself. We'll also be naturally emphasizing key terms and concepts, helping them stick as we prepare you for what lies ahead.
Great. So repeating those key terms will be helpful.
We'll make sure they stand out.
Okay, let's unpack this then. Why is administrative law so important? When we talk about the law, our minds often jump to, criminal trials or big courtroom dramas.
Right, the headline stuff?
Exactly. But administrative law is quieter, yet it's truly the unseen architect of modern society. It's not just for lawyers or academics. It's a crucial part of our day-to-day existence, constantly in the public eye, even if we don't always label it that way.
That's a great way to put it. You might not realize it. But the quiet hum of a delivery truck outside your window, the safety regulations ensuring your morning coffee is safe, or even the quality of the air you breathe.
All shaped by it.
In some way, yes, shaped by administrative law. What's truly fascinating here is how deeply it's woven into issues of great public controversy, which means it's always relevant and often making headline news.
Ah, so it's not always quiet then.
Well, the effects aren't quiet. For instance, consider areas like immigration. Decisions about who can enter, reside, or claim asylum in a country are largely governed by administrative law. This isn't Parliament directly deciding every single case.
No, of course not.
It's executive agencies operating under rules created or at least overseen by administrative law principles. Or take the operation of prisons and the treatment of prisoners. Everything from their fundamental rights to the conditions of their confinement are tightly regulated by administrative law, ensuring the state acts within defined lawful boundaries.
And it doesn't stop there, does it? I mean, environmental regulations.
Absolutely huge area. Things like controlling pollution, managing land use, decisions about resource extraction, they all fall squarely within its purview.
And social welfare policies, too.
Definitely. Think about the systems that determine access to benefits, public housing, or healthcare. These are entirely dependent on complex administrative frameworks. If a business wants to build a new factory, or a developer wants to put up a new housing estate,
Or an environmental group wants to challenge something.
precisely. If an environmental group challenges a government decision on, say, fracking or a new infrastructure project, administrative law is at the heart of those legal battles. It requires deep engagement with complex governmental policy and decision-making because it's about how those policies are formed, implemented, and crucially challenged.
So its applicability is incredibly broad.
Immense. This broad applicability is why understanding administrative law is so vital. It's essentially the operating manual for how government interacts with citizens and organizations on a practical level.
Okay, so it's not just abstract rules. It's about the mechanics of government.
Exactly. It's about understanding how the government actually functions day to day, how it exercises its vast powers, and crucially, the limits placed upon it. It's fundamentally about accountability and the legitimate exercise of power.
Which makes it a natural follow-on from public law, right?
A very natural progression for those of you who enjoyed studying public law, where the main focus was probably constitutional law. While public law might have introduced you to the theoretical framework of governmental power, administrative law dives into the practical application and control of that power in everyday decision-making.
And concepts like judicial review probably came up in public law, too.
You might have touched upon judicial review there, yes. And in administrative law, it becomes a central tool. It's the process by which courts oversee the legality, not the merits, but the legality of public bodies' decisions. We'll be unpacking that concept judicial review much more as we go. It's absolutely key.
Okay, good. Now, you mentioned the link with constitutional law. Here's where it gets really interesting for me, because the distinction between administrative law and constitutional law isn't always precisely delineated, is it?
No, not at all. In fact, they are deeply intertwined. You absolutely need a good understanding of constitutional issues to grasp how administrative law in England and Wales works and why it developed as it has.
So things like separation of powers, rule of law.
Exactly. Fundamental constitutional principles like the separation of powers dividing government into legislative, executive, and judicial branches, or the rule of law. The idea that everyone, including the government itself, is subject to and accountable under the law. These provide the theoretical underpinning for many principles in administrative law, particularly those related to controlling government power.
So administrative law puts those big ideas into practice.
In many ways, yes. It's the nuts and bolts of constitutional principles in action. How do we ensure the executive doesn't overstep its bounds? Administrative law provides many of the answers.
Right. And this naturally raises an important question. What about the significant constitutional tensions administrative law faces today? Because it's not a static field, is it?
Far from it. These aren't just academic debates. They have real-world implications shaping the very promise of justice. For instance, there's considerable debate right now about access to judicial review.
We just established how important judicial review is.
Exactly. We often assume legal recourse is universal, but the reality is, with legal aid significantly reduced over the years, there's a serious concern that claimants without financial resources often simply can't challenge potentially unlawful administrative action.
So justice might depend on your bank balance.
That's the concern. It creates an imbalance, potentially leaving individuals or groups unable to hold the state accountable, even when its actions might be ultra vires. That key term meaning literally beyond its powers, exceeding what the law allows it to do.
Ultra vires, got it.
This reveals a potential vulnerability in our system of checks and balances, impacting the fundamental principle of access to justice.
And another hot topic you mentioned is human rights protection.
Yes, another area of tension. The precise scope of human rights protection. Should the Human Rights Act 1998 be modified or replaced, especially thinking about the context of the UK's withdrawal from the European Union?
This is a huge debate.
It is, because it could potentially reduce the court's ability to declare governmental action unlawful if it conflicts with human rights standards. If the Human Rights Act were weakened, for example, the avenues through which individuals can challenge administrative decisions based on fundamental rights could shrink.
Which impacts that protective regulatory side of administrative law.
Precisely. It's a constant balancing act between governmental efficiency or policy goals and individual liberties.
And the elephant in the room, Brexit.
And of course, the UK's withdrawal from the European Union itself causes great uncertainty for administrative law. EU law has had a really significant impact on its development in England and Wales.
In what ways?
Well, influencing principles like proportionality, the idea that a public authority's action shouldn't go further than necessary to achieve its objective. Also, legitimate expectations.
Okay, legitimate expectations. What's that?
That's where individuals might have a right to expect certain treatment based on past promises or established practices from a public body, and perhaps most fundamentally, principles of procedural fairness.
Procedural fairness, making sure decisions are made properly.
Exactly. Ensuring decisions are made fairly and impartially. The question of what happens to these EU influences post-withdrawal is a major concern. Will concepts like proportionality remain as strongly embedded? Will doctrines like legitimate expectations evolve?
So lots of unanswered questions.
Huge questions. These are complex, evolving areas you'll definitely reflect on in later studies, and they highlight the incredibly dynamic nature of administrative law. The implications of Brexit for the legal framework governing governmental action are still unfolding.
Making it a very current subject to study.
Absolutely. A fascinating time.
So if we look at administrative law from a practical standpoint, how it functions, what are its main jobs?
It's useful, I think, to see administrative law as having two key aspects. They seem almost contradictory, but they work together. Firstly, it's partly facilitative.
Facilitative, meaning it helps the government.
Yes, it provides the tools for government to implement policy decisions. This is crucial because governments need clear legal mechanisms to translate their political agendas into concrete actions.
How did it do that?
Through mechanisms like delegated legislation, remember that from public law, where Parliament grants authority to executive bodies to make detailed rules.
Right, statutory instruments and the like.
Exactly. It also includes rulemaking by various agencies, the proper exercise of discretion, where officials have a degree of lawful choice in applying the law, and the making of specific administrative decisions that affect individuals or groups. These facilitative aspects are about empowering the state to govern effectively and efficiently.
Okay, so that's the empowering side. And the second aspect, this must be the control side.
Exactly. The flip side, it's regulatory. Administrative law provides mechanisms for grievance redress.
Okay, regulatory, how does that work?
It allows individuals or groups to challenge the state when they believe it has acted unlawfully or unfairly. This includes crucial avenues like judicial review, that concept you must remember.
Judicial review again? Central.
Absolutely, where courts scrutinize the legality of administrative action, not the wisdom of the policy, just its lawfulness.
And are there other ways besides court?
Yes, definitely. There are tribunals. These are specialized bodies, often providing a more accessible and informal way to resolve disputes with public bodies, think Social Security benefits or immigration decisions.
More specialized, maybe quicker.
Often, yes. Then there's the ombudsman, an independent official who investigates complaints against government departments and public organizations. It's a non-judicial avenue for redress.
Like a watchdog.
A kind of watchdog, yes. There are also various internal complaints systems within agencies themselves, or even sometimes actions in private law, like tort or contract claims against public bodies, though these are generally less common for purely administrative grievances.
Okay, so a whole range of tools. This leads to fascinating questions like, who can actually use these tools? Who can challenge government actions or decisions?
Exactly. Is it just directly affected individuals? Or can businesses, pressure groups, or even other governmental bodies make a challenge?
This sounds like that standing concept again.
It is. This delves into the concept of standing, which is about who has the legal right to bring a case. It's a fundamental hurdle. And then exactly how can these challenges be brought? What procedures must be followed? What are the time limits?
Practical questions.
Very practical and absolutely fundamental questions that you will explore in depth as you progress through the module. They are central to understanding the practical application of administrative law. The answers determine the accessibility and effectiveness of these regulatory mechanisms. So how easy is it, really, to hold power to account?
That's the core question administrative law constantly grapples with. As you'll see, it's a subject of great complexity. It builds directly upon your previous studies in public law, deepening your understanding of the state's powers and limitations.
But you also mentioned links to other areas.
Yes, it will also require you to apply your thinking from contract law and tort law. For example, principles of remedies and liability from tort law might be relevant when considering compensation for administrative wrongs.
Ah.
And concepts like legitimate expectations, which we mentioned earlier, might draw parallels to contractual understanding, where a promise or representation creates a form of reliance.
So it connects different legal fields.
It really does. This interdisciplinary nature makes the subject intellectually stimulating and broadly applicable, helping you connect the dots across your legal studies. Okay, let's talk about the module guide itself, the one this deep dive is based on. It's designed to help students achieve specific aims. What are they, and how do they shape the learning journey and prepare people for the assessment?
Right. The guide has three core aims. Firstly, to help you understand the profound impact that constitutional law and practice has on the operation of administrative law.
We've touched on that link already.
Exactly. It means recognizing how fundamental constitutional principles like parliamentary sovereignty, the rule of law, and the separation of powers underpin the development and application of administrative law in England and Wales. It's about seeing that big picture connection.
Understanding the foundations.
Precisely. Secondly, you're expected to develop a strong appreciation of the case law on judicial review and offer a critical analysis of its development.
So not just knowing the cases, but analyzing them.
Yes. Judicial review is the cornerstone. This aim encourages you not just to memorize cases, but to understand the evolution of the court's role, identify trends, and critique the principles that have emerged. Asking why the law developed this way. Is judicial review actually working effectively?
Okay, a critical perspective. And the third aim.
The third aim is to offer a critical analysis of administrative law from that functional perspective. We discussed questioning how effective it is in its facilitative and regulatory roles.
So, evaluating how well it does its jobs.
Exactly. Is the government adequately equipped by law to implement policy effectively? And on the other side, are citizens truly able to seek redress when things go wrong? This analytical approach is vital, pushing you to think like a legal reformer, not just a legal scholar.
Okay, those are clear aims. Now,
Okay.
beyond just reading the guide, how can the central resources best support learning and exam preparation? There's quite a bit available on the VLE, isn't there?
There is, and using it effectively is key. First and foremost, you must make use of this module guide. It is your primary roadmap.
The absolute starting point.
Absolutely. It meticulously details what you're expected to know, crucially,
Yeah.
what might be tested on the exam. It explains important points of law, provides excerpts from relevant legislation and essential case law, and it guides you to the best reading. Consider it your foundation.
And the activities in the guide. And the VLE.
Definitely engage with the activities in the guide and use the feedback on the virtual learning environment, the VLE. These activities aren't just optional extras. They're designed to help you check your understanding, pinpoint weak spots, and reinforce learning.
And the feedback is important.
The feedback provided on the VLE is gold. It highlights common misunderstandings and shows you how to improve. Use it actively.
What about the vodcasts? Are they helpful?
Don't overlook the vodcasts on the VLE. These video podcasts are specifically designed to develop your understanding of particular issues, explaining core concepts and key case law visually.
So, a different way to learn.
Yes, sometimes seeing a concept explained or a complex case summarized visually and audibly can really click, especially for tricky legal principles. They offer a different, often more engaging way to interact with the material, like a mini tutorial.
Okay, now this one sounds crucial for exam prep. The examiner's reports.
Absolutely critical. The examiner's reports on the VLE offer invaluable insights into the strengths and weaknesses of previous exam answers. They show you precisely how to improve your own.
So they tell you what examiners are looking for.
Exactly. They show what distinguished a top-scoring answer from an average one, and crucially, what common mistakes students made. It's worth stressing again, the examiner's reports are crucial for understanding exam expectations and refining your technique. If you want to know how to impress the examiner, read these reports carefully.
Right, essential reading. What else on the VLE?
Also, be keenly aware of materials circulated on the VLE, especially the pre-exam update.
Why is that so important?
Because law, especially administrative law with its constitutional links, is dynamic. This update draws your attention to the most important recent developments, new case law, new legislation perhaps. Staying abreast of these changes is vital.
So the law might change just before the exam.
It can. It's worth repeating. Staying updated with recent developments is key, particularly for the exam, as questions may incorporate these current issues. It tests your grasp of a living, evolving body of law.
Okay, stay current. And finally, online resources like blogs.
Yes, to keep abreast of the very latest legal developments and gain wider critical perspectives, it's highly beneficial to follow and read some of the recommended blogs and other electronic resources. These often provide timely analysis of new judgments or legislative proposals, keeping your knowledge current and offering viewpoints that can really elevate your essays.
Adds another layer to the understanding.
Exactly. They're like having front row seats to legal debates as they unfold. Now, like all law degrees, administrative law involves a great deal of reading. There's no getting around that. It has predominantly grown from common law roots.
Meaning lots of cases.
Meaning there are a great many cases, judicial decisions, that have shaped and defined the law. In fact, appellate courts, like the Court of Appeal and the Supreme Court, the highest court in the UK, frequently hear administrative law cases.
So case law is central.
It's a central pillar of your study. Many principles have been developed and refined through these judicial decisions. Understanding these cases is fundamental. They are where the principles come alive.
Okay, so lots of reading. How does the guide help manage that?
The guide aims to help you manage this by encouraging you to focus on the most important cases and readings first. Then, once you have that foundation, You deepen and enhance your understanding with additional materials.
Building it up in layers.
Exactly. It's about building layers of knowledge, starting with the essentials before moving to more detailed or nuanced discussions. This strategic approach prevents information overload and ensures you grasp the foundational concepts before diving into complexities. Think of it as a scaffold.
So what's a good strategy for tackling the reading?
A good strategy would be a tiered approach. Firstly, focus intently on the material in this module guide itself, especially the key cases and concepts it highlights. This guide is your filter for the absolute necessities.
Start with the guide. Then?
Secondly, read the core textbook for background. This provides a structured overview, placing the concepts from the guide within a broader context.
Which textbook is that again?
We'll get to the specific books in a moment. Thirdly, for deeper understanding, focus on key articles from academic journals. These offer critical perspectives and detailed analysis beyond textbook summaries, helping you develop your own critical voice.
Journal articles for depth.
Yes. And finally, at the end of each chapter in the guide, there's further reading. Use this for areas that particularly interest you or to bolster your knowledge in specific weak spots. It's for targeted exploration.
Right, a clear plan. So let's talk specific textbooks. The core recommended one is Endicott T. Administrative Law. Why that one?
Endicott is an excellent introduction because it explains many core issues with remarkable clarity. It covers the major cases fundamental to the subject and, importantly, places the law in an interesting theoretical context.
So it's clear and gives context.
Yes, its clarity is great for getting to grips with concepts like, say, irrationality in judicial review. It's a valuable first step for understanding the basic framework without getting bogged down in excessive detail that might overwhelm a newcomer. The module guide links directly to relevant chapters in Endicott, making it easy to integrate.
Okay, Endicott first. What about other significant texts we should be aware of? Perhaps for more detail later.
Absolutely. There are several heavyweights.
Hmm.
Craig P. Administrative Law is very famous, well-respected, written by a leading expert. Its strength is its immense depth, intricate detail, and comprehensive coverage of case law and theory.
The Bible, maybe.
Often considered that, yes, for its thoroughness. But that same strength means it can be less user-friendly for beginners due to the sheer detail. Use Craig once you have a solid grasp from Endicott. It's fantastic for drilling down into specific areas or finding extensive case lists. Remember, Craig is deep and authoritative, but perhaps not the first choice for beginners.
Okay, what about a different angle? More theoretical, perhaps.
For a more theoretical lens, Harlow's C&R Rawlings Law and Administration is valuable. It's excellent for its introduction to theoretical issues, maybe less so for detailed substantive law. It helps understand the why behind the rules debates about judicial activism versus restraint, for instance.
Good for context. Any others?
And then there's Wade, W&C Forsyth Administrative Law, another valuable and authoritative textbook. This one is particularly strong on the historical development of case law on many issues.
Good for seeing how things evolved.
Exactly. And its analysis of remedies and standing are particularly strong sections. Wade is excellent for understanding how these key practical concepts, remedies and standing, have been molded by the courts over time. Repeat. Wade is strong on case law development, remedies, and standing.
Got it. What about resources aimed at practitioners, like lawyers in the field? Are things like Fordham or DeSmith relevant for students?
Good question. Judicial review, being such a major focus, does have excellent practitioners' texts, like Fordham's Judicial Review Handbook and DeSmith's Judicial Review.
But are they for students?
They're not really starting points. They assume a lot of existing knowledge and focus on the practicalities of litigation. They can be useful later for a very deep dive into a specific legal issue, maybe for a dissertation, or just to see how the law works in practice. But remember, these are practical, not theoretical, and definitely not mandatory reading for the module.
Okay, useful to know they exist, but not essential. And casebooks. Do we need one?
Fortunately, administrative law hasn't seen the same explosion of casebooks as other subjects. Elliott, M. and J. Verhulst's Administrative Law, text and materials is available, offering excerpts of legislation and case law.
But is it necessary?
Honestly, if you diligently use the module guide, which has excerpts, the recommended textbooks, and supplementary journal readings, you should get a really good sense of the law without needing to buy a separate casebook. They can be handy, but probably not essential if you use the other resources well.
Good to know. Now, staying current and getting critical perspectives, journals seem key here.
Journals are absolutely vital for that critical engagement and keeping up. There are two specialist journals, Public Law and Judicial Review. You'll be frequently advised in the guide to read specific articles from these.
They focus just on this area.
Yes, primarily public and administrative law. They feature cutting-edge analysis of new case law or legislative developments from leading academics. Plus, articles on administrative law often appear in the major general legal journals like the Law Quarterly Review, Cambridge Law Journal, and Modern Law Review.
So reading these really helps.
Massively. It's worth repeating. Reading journal articles significantly enhances your understanding, offers those crucial critical perspectives, and can markedly improve your exam essays. It allows you to incorporate more nuanced arguments and show wider knowledge. It's often what separates a good answer from an excellent one.
Okay, journals are a must for top marks. Finally, the internet. Lots of info, but how do we find reliable sources?
Precisely. Quality varies wildly online. However, some academics and practitioners maintain excellent authoritative blogs. Highly recommended are Professor Mark Elliott's Public Law for Everyone blog, superb posts on admin, public, and constitutional law, great for keeping up.
Okay, Mark Elliott's blog.
Then the UK Constitutional Law Association blog. Despite the name, it frequently covers important administrative law issues, especially where they overlap with constitutional law. The UK Human Rights blog offers great material and very helpful case summaries, vital given the human rights connection.
Good for case summaries.
And finally, the Admin Law blog. Relatively new, but regularly updated with excellent material on admin law across the common law world. These blogs are fantastic for staying current, getting insights, and finding timely analysis of recent judgments, often explained very clearly.
Great tips, thank you.
Yeah.
Let's talk study habits. Everyone's different, everyone has different amounts of time, but what's the key principle for studying administrative law effectively?
Yeah.
How much time should students realistically budget each week?
Well, there's no doubt that if you want a good understanding, and certainly if you want to do well in the exams, you need to set aside dedicated time each week to study the material and do the reading.
So consistency is key.
Absolutely. This isn't a subject you can effectively cram in the last few weeks. It requires consistent engagement. And don't underestimate the power of continuous revision.
Meaning revise as you go.
Exactly. It's best done as an ongoing process. As you complete each chapter or topic, set aside time to revise it. This reinforces learning, helps identify gaps early, and makes the final revision period much less stressful. Regularly tackling the activities in the module guide and checking that VLE feedback is part of this to active learning, not just passive reading.
Okay, continuous work. And as the exam gets closer, how should the study strategy change?
You'll definitely need to dedicate additional time then. But the focus shifts. At this stage, it's less about absorbing brand new material and more about developing your thinking to provide excellent exam answers.
Thinking, not just knowing.
Yes. Moving beyond understanding concepts to being able to analyze, critique, and apply them under exam conditions. So if you feel confident in certain areas, use that extra time to read more journal articles for wider critical perspectives. This adds sophistication to your arguments.
And for weaker areas?
For weaker areas, intense, focused study is needed. Draw particularly on the core textbooks and module guide to really build up that foundational knowledge framework. It's about strategically allocating your time. Consolidate weaknesses, then deepen strengths.
That makes sense.
Yeah.
Now it can feel overwhelming, all the case law, the theory. What should students realistically aim for? We don't need to know everything perfectly right.
That's a very important point to reassure students about. We don't expect you to know absolutely everything in the module guide to a perfect level, nor to have read absolutely everything referred to. That's impossible and unnecessary.
So what is crucial?
What's crucial for the assessment is a solid knowledge of the core areas covered by the syllabus. Understanding the fundamental principles, the key landmark cases, and the major debates in each core topic. Preferably, this core knowledge should be complemented with insights from some of the relevant case law and journal articles so you can demonstrate deeper understanding and critical engagement in your assessment.
Quality over quantity.
Definitely. It's about the quality of your understanding and your ability to apply it, not just the quantity of facts memorized. Being able to connect case law to theoretical arguments, for instance, shows much higher understanding than just listing case names. Aim for depth in the key areas.
Okay, that's reassuring. And looking beyond the exam, what's the long-term benefit of studying this? How does it help in future careers?
Beyond the exam, a strong knowledge of administrative law is likely to serve you incredibly well, whatever your future career path, whether it's in law or elsewhere.
Really? even outside law.
Yes, almost all areas of life, work, and business are touched by issues of administrative law in some way. Think about regulations, licenses, planning permissions, interactions with government agencies.
True, it's everywhere.
Exactly. Whether you end up in private practice, working for the government, in a corporation, or for a nonprofit, you will inevitably encounter situations where governmental regulations, decisions, or policies impact your work. Understanding administrative law gives you a crucial framework for navigating these interactions, knowing how to challenge actions if necessary, or advising on compliance.
So it's a practical life skill almost.
It's a truly practical and pervasive area of law. It equips you with skills to understand and interact effectively with the state, which is valuable in almost any professional context. It's the law that shapes so much of our everyday world.
Like, let's get down to the assessment itself, the exam. After all the study, how is it structured? What kinds of questions can students expect? Let's demystify the exam paper.
Okay. The assessment is a 3-hour, 15-minute examination. You're expected to answer 4 questions in that time.
3 hours 15 for 4 questions. That allows some decent thinking time.
It does. It allows for thoughtful and detailed responses, so definitely plan your time, but don't feel overly rushed. The paper itself will have 7 essay questions and 1 problem question.
7 essays, 1 problem. And the choice.
This is important. You are not required to answer the problem question. You can choose to answer 4 essay questions if you prefer. Or you could do 3 essays and the problem question.
Ah, so there's flexibility.
Yes, great flexibility based on your strengths and preferences. That's a real advantage.
Okay. And the types of questions themselves, will they be broad overview questions or really specific ones?
They vary year to year. Some questions are indeed more general, requiring a broad knowledge of module themes, perhaps asking you to synthesize concepts across different topics or compare approaches.
Like comparing judicial review with tribunals, perhaps.
Could be, yes. Others are more specific, demanding substantive knowledge of particular areas. You really need to know the detail on topics like control of discretion, how courts review the exercise of administrative power to ensure it's lawful and not arbitrary.
Okay, control of discretion. What else?
Also, procedural fairness. Those rules of natural justice, like the right to a fair hearing, that public bodies must follow.
Procedural fairness, got it.
And standing again, who has the right to bring a claim? Or legitimate expectations where individuals might have rights based on past practice or promises. You need solid knowledge of these specific doctrines and the key case law associated with them. Remember those. Control of discretion, procedural fairness, standing, legitimate expectations.
Okay, those are key topics for specific questions. And the problem question.
Problem questions are different. They present a factual scenario and ask you to advise a fictional client. They are challenging because they often require you to spot and apply rules from multiple areas of administrative law.
More like being a real lawyer.
Exactly. But they offer a very structured way to demonstrate your understanding and simulate legal practice, which can be very rewarding if you approach them systematically.
Right. Let's talk essays first, then. How do we write a high-scoring essay in administrative law? It's not just about listing facts, is it?
Definitely not. Essay questions test not just your knowledge, but crucially, your analytical skills. Your marks will be significantly boosted by using a robust analytical framework. Have a clear argument, a thesis, and structure your essay to support it logically.
Structure is key.
Absolutely. The best essays typically have a clear introduction. This should explain your approach to the question and briefly outline your main arguments, tell the examiner where you're going.
Set the scene.
Precisely. Then comes the substantive body. This needs to be well developed, drawing directly on relevant case law, relevant statutory material if applicable, and critically, perspectives from the literature books, those vital journal articles, maybe even reputable blogs to address the question directly and critically.
So evidence and analysis.
Yes. Demonstrate you know the law and can think critically about it. And finally, a strong conclusion. This should tie everything together, summarize your main points, and offer a clear, concise answer to the specific question asked. Leave the examiner with a strong final impression. So remember that structure. Introduction, substantive body with case law and literature. Conclusion, it's vital.
Okay, structure, evidence, analysis, conclusion. What about specific exam technique pointers for essays? What are the big DOs and don't-outs?
Okay, some key pointers here. 1. DO adopt a clear structure. Make sure it directly answers the question asked and explain how your points connect logically. Signpost your argument.
Guide the examiner.
Exactly. 2. Do make reference to relevant examples. Use specific examples from statute, case law, and the literature to support your points and introduce critical perspectives. This is non-negotiable for good marks. Repeat. Specific examples from statute and case law are essential. You can't just talk theory.
Ground it in specifics.
Yes. For instance, discussing procedural fairness without mentioning Ridge v. Baldwin or similar key cases just won't cut it. 3. DO ensure you have knowledge of enough areas of the module to answer 4 questions sufficiently. Knowing only 2 topics really well won't work if you can't find 4 questions you can answer. Broad coverage is important.
Spread the knowledge.
Within reason, yes.
Yeah.
4. Do not loan answers by rote and then try to force them into vaguely similar questions. Examiners spot this easily. It rarely addresses the specific question properly and won't earn much credit. Adapt your knowledge to the question asked.
No pre-cooked answers.
Definitely not. 5. Do not write very general responses with no reference to practical examples from statute or case law unless the question is unusually abstract. An essay on, say, rationality review or standing with little or no mention of the key cases that develop those principles is unlikely to pass. Repeat. Avoid purely abstract answers. Ground them in specific case law and statute for concepts like procedural fairness, standing, and rationality review.
Okay, those are very clear do's and don'ts. Now, problem questions. They require a different approach, right? How should we tackle them?
Yes, a different mindset. Instead of analyzing the law generally, problem questions test your ability to identify legal issues in a specific factual scenario, apply the relevant law to those facts, and then advise a client on their position.
So, spot, apply, advise.
That's a good summary. They can seem challenging, but the structure they provide can actually be very helpful.
What's a good structure then?
A useful approach for admin law problems is to first cover generally applicable issues right at the start before diving into the specifics of the complaint.
Like preliminary issues.
Exactly. Ask, do the clients have standing? Do they have the legal right to bring this claim? Have they exhausted other potential remedies, like internal complaints or the ombudsman? Are the issues even amenable to judicial review? Is this a public law matter the court can review? Addressing these initial hurdles, repeat. Standing and amenability to judicial review is critical. Get them out of the way first.
Okay, cover standing and amenability first.
Right.
Then what?
Then, identify the specific legal issues raised by the facts. What exactly has the public body allegedly done wrong? Break them down into sub-issues if possible. That shows sophistication. Next, identify the relevant law applicable to each specific issue you've spotted. This is where you bring in your knowledge of case law and statute.
And mention conflicts in the law.
Yes, you'll gain additional credit if you identify any conflicting approaches in the case law on a particular point, and then argue which approach is most likely to be adopted here, justifying your reasoning. That shows deeper understanding.
Okay, apply the law, note conflicts, and finally,
Advise the client. Based on your analysis, what is the likely outcome? What should they do next? Importantly, be realistic. If their claim looks weak, tell them why. This is about practical advice.
and mention remedies.
Yes. You'll receive particular credit if you can advise the client on the remedy they might obtain if successful. Would a quashing order, nullifying the decision, be appropriate? Or a mandatory order, compelling action? Or a prohibiting order, stopping an action? Repeat. Advising on potential remedies demonstrates comprehensive understanding of the practical consequences. Hashtag outro.
And there you have it, a really comprehensive deep dive into the fascinating and clearly crucial world of administrative law. We've used the module guide as our map, exploring why it's so important, the resources available, reading strategies, study habits, and how to tackle that final assessment.
Hopefully that gives everyone a much clearer picture.
It really feels like a subject that touches everything.
It does. And remember, this module guide, along with all the other resources we mentioned, the vital pre-exam updates, the feedback from previous examiners' reports, the helpful vodcasts, are all specifically designed to support your learning and help you succeed.
They're tools to be used.
Exactly. And your feedback on them is always welcome, by the way, to help improve these materials for future students. Continuous improvement benefits everyone.
We are truly glad you've chosen to study administrative law. We're confident you'll gain immense benefit from it, both academically and, as we discussed, probably in your future career too.
It's a field that's constantly evolving, always relevant, and offers real intellectual rewards.
We genuinely hope you find the module an enjoyable experience.
Yeah.
And that this deep dive has given you a real boost in your preparation.
Absolutely. And perhaps to leave you with a final thought to ponder as you continue your studies.
Okay.
Given the complex and ever-evolving nature of administrative law, particularly with those ongoing constitutional tensions and the debates around things like judicial review and human rights that we talked about, What responsibility do we, as future legal professionals, as informed citizens, have in ensuring effective governance and genuine accountability of state action in our increasingly complex world? How do we strike that right balance between efficient government action, which we need, and the absolute imperative to protect individual rights and ensure legal certainty for everyone? It's a challenge administrative law grapples with every single day.
That's a great question to ponder, a really important one. Thank you for joining us on this deep dive. Good luck with your studies, everyone,
Yes, best of luck.
and we'll see you next time.